I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today we are discussing AI and consumer protection. Many people in the AI space, especially in the US, see AI and think privacy. And for good reason. AI is raising many important privacy challenges and issues. But a sole focus on privacy is too narrow. AI is raising many more consumer protection issues, of which privacy is only an example. And that's where I want to focus today's episode, with a particular focus on the role of state AG in enforcing and interpreting consumer protection laws with respect to AI. This episode is a continuation of our AI Mastery series on how to spot issues raised by AI across legal disciplines. If you are new to the podcast, check out some of our prior episodes in the AI series that cover ground like AI and IP, cyber, and antitrust. They are a great resource for learning how AI technology is creating legal issues in a variety of ways. We just did a terrific episode regarding data centers, AI, and how the confluence of those two things were shaping energy policy. That episode was fascinating. Give it a listen. While I learned from that episode the uncertainty regarding how we are going to physically power the hardware needed to support AI, one thing was clear. AI policy debates are here to stay. Whether it's energy policy or consumer protection laws, we have a lot of hard thinking in front of us. So for today, how is AI shaping consumer protection policy? USAG has a lot of authority and power to interpret laws that are written at a very high level. States, for example, have many FTC acts that generally prohibit unfair or deceptive trade practices. Many times that's all they say. What does that mean with respect to AI? What is unfair or deceptive when it comes to AI-based technology? Well, that's a good question. And to help answer, I have invited my partner, Jason Downs, from our state AG practice to the podcast. Before joining Hogan, Jason has spent many years in the DC AG office, where he was the Chief Deputy Attorney General for the District of Columbia. And as you'll hear, in that role, leaned into AI policy, AI enforcement, and frankly brought coordination amongst many attorney general about how collectively AG was thinking about consumer protection in connection with artificial intelligence. Jason, welcome to the podcast.
Thanks so much for having me, Scott. Looking forward to talking with you.
So, Jason, you're coming to Hogan having had a long career in law enforcement, working in AG offices, and have been working on consumer protection issues for more than a decade. I'm interested in maybe starting the conversation from your perspective. How is AI creating new and unique consumer protection issues?
Thank you for the question. Really appreciate it. What I see here is that artificial intelligence is just exacerbating existing consumer protection issues. I wouldn't go so far as to say it's creating new issues as it is exacerbating them and making them more poignant. And you're seeing, for example, state attorneys general paying closer attention to the effects of artificial intelligence. I would suspect that many AG understand the benefits of artificial intelligence, but I will say that over the last few years, state attorneys general have started to understand the negative effects, and they've tried to be a bit more cognizant. And this is a bipartisan issue. As recently as 2021, there was a conference for all chief deputy attorneys general around the country. It took place in Memphis, Tennessee, and I had the good fortune of leading the conference alongside of then Chief Deputy Jonathan Skrmetti. He's currently the Attorney General of Tennessee. The reason why I bring that up is to highlight the fact that the conference was led on a bipartisan basis, and the issue is bipartisan. There were Democrats and Republicans in the room, and the whole purpose was for the chief deputies, the number two officials in every office, to understand how to use the office's consumer protection authority more thoughtfully as it relates to artificial intelligence. And I would say one big takeaway from that conference is that AG offices are more attuned to how companies are reviewing and scrubbing and ensuring that their training data sets are not sort of perpetuating historical biases. And I'm sure we'll get into that in a few moments. But the point I'm making is it was a pretty robust conference. It lasted for several hours. It was well attended. It was bipartisan. And AG offices are very interested in ensuring that they use their consumer protection authority thoughtfully as it relates to consumer protection and AI.
Yeah, I mean, that's really fascinating. And I want to kind of go into maybe some of the learnings from that past experience and how you see those being, developing over the next period of time. As I think about maybe, what consumer protection is in this context. I mean, obviously, consumer protection is a broad term that covers a lot of different type of legal principles, but it could be the aspect of looking at very specific laws, and we're starting to see obviously very specific laws pop up in California and Colorado and Utah and elsewhere around AI. But more importantly, if you think about how the consumer protection principles are coming in, consumer protection is not new. We've been, enforcing consumer protection principles in this country for a very long time, including under Section 5 of the FTC Act and the state equivalent mini FTC Acts, that also prohibit unfair or deceptive trade practices, which is very broad in terms of its language and also broad in terms of its application. So as individual practitioners in this space are thinking about, hey, I need to get out ahead of trying to make sure that I'm protecting consumers in the way that I'm developing AI, the way I'm using AI, how I'm building out my overall compliance program. What are like the specific kind of sub issues that you're thinking about, right? That aggregation or combination of all of those other issues you mentioned, that this is not really new. This is a creation of a bunch of things that we've been doing for a long time, but now perhaps with an overhang of a different set of technology?
It's a great question. Thanks for asking. I think in that scenario, one of the first things I recommend is organizations make sure that there is human intervention early and often. And I say that because if and when a regulator comes knocking and asks questions about how an artificial intelligence system works and what impact it has on consumers, whether it's raising prices for consumers or whether it's making recommendations as to pricing or whether it's making recommendations as to who sees a particular advertisement, it's really important to be able to say that humans were involved early and often. And one way to do that is start off by just having a periodic basis on which you audit the artificial intelligence system or systems that you're using. And by audit, I mean, consider ensuring that the general counsel or someone in the GC's office understands what factors the artificial intelligence system is using to make recommendations. And that question may seem like it's foundational, but it's not always basic. It's really, having a really keen and clear understanding as to the factors that the system is using. Next, I would recommend understanding or comparing those factors to factors that are prohibited under either federal law or state law. And I say that because I've been involved in auditing a very sophisticated company's artificial intelligence system as it related to hiring. And this company was not completely aware that it was using a hiring artificial intelligence system that took into account an applicant's graduation year and query whether the company really wanted to use graduation year, because the real question is how much experience did the person have in a particular area or for a particular job. Using graduation year could be a proxy for age. And so one recommendation we made was to just change that particular factor. And so what I'm getting at is that when you're thinking about compliance, one thing you want to think about is understanding all of the factors that the artificial intelligence system is using, comparing those factors to prohibited traits under federal and state law, And then if there are any recommendations that need to be made, whether it's changing some of the factors, changing the weight that some factors are given, that can and should be done by with via human intervention. And you may ask why I'm talking about discrimination as opposed to consumer protection. And the answer to that is that both bodies of law, they really overlap in a really meaningful way. And that is they're both looking to stop unfair practices. So when you're talking about a consumer protection case, state AGs are looking to protect consumers from unfair trade practices. That's what they're looking to do. In discrimination cases where AGs have authority, they are looking to do the same thing. They're looking to stop unfair discrimination. And I've seen state attorneys general sit down and have conversations about the best mechanism to bring a case to stop an unfair practice. And because consumer protection statutes are broader than discrimination statutes, you see state AGs deciding to use consumer protection statutes to remedy traditional cases that you would think about discrimination. Here's a concrete example. There was a housing discrimination case a few years ago, and the allegation was that protected classes were being rejected from housing in a particular jurisdiction. That sounds like a traditional discrimination case. But instead, the state attorney general brought a consumer protection case. And the argument was that by violating a law surrounding discrimination, you were inherently violating the CPPA, which is the Consumer Protection and Procedures Act. And that case was heavily litigated, resolved for $10 million. The reason I flagged that is to say state AGs are being very intentional about using their consumer protection authority specifically as it relates to discrimination. And so I would be really careful if you're using an artificial intelligence system to make sure that the artificial intelligence system is not inadvertently discriminating against protected classes, because that's the kind of thing that can open up a company to a CPPA claim.
Yeah, I mean, that's fascinating. And Jason, you hit on so many different things there. But, I heard you describe the principles that are at the core of AI-oriented legislation, policy, whether that be areas of accountability and having kind of the underlying documentation about how this is being created, or transparency in showing consumers how AI is being used, explainability of having humans involved to be able to oversee this, or, bias and fairness, accuracy. And so much of kind of these repeated themes about how AI is creating new legal issues in existing areas is really sounds like coming up quite clearly and directly with inside of the consumer protection space. And so as you started by saying, hey, AI and consumer protection is a really important thing, but don't think necessarily just about consumer protection as the end destination. It's really just that combination of all of those many other aspects of what it is that you would need to do for any type of technology company who is launching these types of solutions in the market.
Yeah, that's a great point. And you touched on an issue, transparency and explainability, Scott. And that's an issue that the FTC has been laser focused on, and state attorneys general have latched on. I forget exactly which month it was, maybe 6 months ago or so. Current chairwoman Lena Khan mentioned that there is no AI carve out to consumer protection laws, and the lack of ability to explain how an artificial intelligence system works, that's not a defense. And state attorneys general have really latched onto that and asking and issuing subpoenas or issuing CIDs and asking companies to articulate both in writing and in a full-blown meeting how an artificial intelligence system works. And if a company is not able to do so, that is the kind of thing that will draw the scrutiny of the FTC and state attorneys general.
Yeah, I mean, I'm interested going back quickly to the prior example, Jason, you mentioned, because it's one that I frequently hear around the uses of AI tools to help better employment related decision making. When you have a job posting, I have a client who says, I post up a job and I'll get 25,000 applicants for it, right? And trying to, if anyone ever looked at 100 resumes, your eyes start to gloss over in some ways to try to be able to separate out how to decipher who is the best person for this. And, that's 100 versus 25,000. And so in some ways, machines can be helpful about trying to come up with the meaningful distinctions, but sorting through resumes and making hiring decisions has long been a practice of humans. And, a prior guest on this podcast, who was the commissioner of the EEOC, had said, you know what, who discriminates more than machines? Humans. Humans discriminate more than machines. And so if I find myself using a machine that has using graduation year, for example, as a proxy for something else, my guess is that humans have been doing that for a long period of time, and it's never drawn the attention or a scrutiny than perhaps it's getting now. From your perspective, why is there the difference, right? What is the important component of humans probably introducing bias than machines introducing bias?
Well, it's a great question. Well, people tend to rely on machines in a way that they don't when it comes to humans. I think we all know that humans are fallible. There is a perception, it's certainly incorrect, but that machines and artificial intelligence is infallible and that the machines are not going to make mistakes. And that how can a machine discriminate against someone? How can a machine create pricing differences that one community receives one set of prices and a different community receives a different set of prices? A machine isn't biased. A machine can't do that. So I think that's why state attorneys general would scrutinize even more bias stemming from artificial intelligence because of the misperception that machines are infallible. And if we go down this path too far and we don't get a hold on the type of data that artificial intelligence systems are being fed to make recommendations, then we can go down a rabbit hole of just relying completely on artificial intelligence instead of using AI in the way that many companies that are responsible are using it now. Just like you said, sifting through 2,500 resumes is incredibly time consuming. But instead of letting a machine make a hiring decision, having a machine make a recommendation as to who gets interviews, that is probably much more defensible than just having a machine make decisions. Same when it comes to pricing.
Yeah, I'm interested in that pricing component, but maybe another follow-on point to the one you're saying, the reliance on the machine, right? Obviously AI in some ways is designed to make our jobs easier, because you can ask a question and spit out a response, and as we all know, is that doesn't necessarily be the right response to the question that we would asked, but it requires a level of expertise to know what is wrong and what is right about the response that you get. And so the over reliance on it without the underlying expertise about how to use that and be able to identify the problem is one issue. But then that creates any type of bias that is identified or not identified or that is inherent can create a scale problem, right? Because, even in my example, you have one reviewer of resumes who is introducing bias. Okay, well, that's from an impact perspective, likely going to impact those resumes that person reviews. But if everybody is using the same tool that has introduced bias, then everybody is subject to that same bias, right? So the ability of scaling a bias-based decision can happen in AI in a way that perhaps in human world it can't.
Yeah, absolutely. Absolutely. And I think that's exactly right. What you'll see with some of the attorneys general is they'll ask just flat out, what types of audits have you done internally to weed out bias and what have you done about it? And if the answer is no audits, no reviews, that is the type of thing that will draw their scrutiny. Now, some AG, for example, the DC Attorney General sought to introduce legislation requiring bias audits. That legislation did not pass the DC Council, but it is the kind of thing that I've heard, and I've heard with my own ears, state attorney general ask in determining whether they should bring an action. So one question they have is, how are you mitigating against what are you doing to mitigate against bias, and how are you keeping track of the results of the artificial intelligence systems that you're using? And are you using an unbiased third party to conduct such an audit, or are you doing it in-house? And those are questions that differ from company to company. But I think that the more sophisticated we get with artificial intelligence, the more companies want to decide how they're going to do audits, who they're going to use to do the audits, whether the audits will be conducted with maximum protections related to the attorney-client privilege. Are lawyers going to be involved? Will there be statisticians involved? Who's going to be involved in the audits? But I suspect that many companies are making these decisions right now.
Yeah, I mean that's fascinating because it is an area where I think we see so many data points to reinforce that from a consumer protection perspective, just looking at the underlying authority of prohibiting unfair, deceptive trade practices. Uh, I think we've seen the FTC come out and say that the uses of technology without the underlying governance that would be designed to assess that technology, to review the impact of that technology, to understand how that can be used responsibly with the right stakeholders together, that itself is an unfair trade practice, right? In other words, like
Exactly.
the process by which you use to decide to go to market with something or to deploy a piece of technology, if that wasn't adequately reviewed internally by the right people, that is unfair. And I think, it wouldn't surprise me at all to say that even if the DC Council or the states decided not to introduce a specific piece of legislation that says you have to do AI bias audits or AI, different type of third party assessments, that AG are going to say, okay, that's fine. You didn't do that, but my law still requires that you deploy this technology in a fair way. And fairness in this context means you have done those reviews.
That's exactly right. I couldn't agree more. And even adding to the risk there is that the penalties surrounding a violation for the Consumer Protection and Procedures Act, those penalties can add up on a per violation basis, right? And so again, while we're talking about bias and traditional discrimination claims, the penalties there, I'm not suggesting they're minor, but the penalties for consumer protection violations could be as high as $10,000 per violation. And then counting a violation that's a whole different area of law, right? And so it may not just be the one time that the product went to market. In fact, it won't be just the one time the product went to market. It may be as high as every time the product was advertised, or how many consumers saw the particular advertisement that was unfair, that did not fairly warn consumers that artificial intelligence was used in making pricing decisions or marketing decisions. Um, and so what I'm getting at is that I couldn't agree more with your analysis, but I think the stakes are really high because state level consumer protection acts call for very high penalties, and they could be on a per violation basis. I've seen some as high as $10,000 per violation.
Yeah, I mean, 100%. And I think that's really important to know, right? That the stakes here of getting this wrong, or perhaps maybe another way of saying that not doing things correctly in the connection with the development or use, can have really significant downside consequences. Maybe as we're kind of wrapping here, I'm interested in where you're seeing this perhaps go, because we have many AG in this country, and as a result, each of them have their own enforcement priorities, their own perspectives about what constitutes an unfair or deceptive trade practice. Many of which have probably different levels of understanding surrounding what AI is, the consumer protection risks that AI generates. Some may be thinking about it as a privacy issue. Some may be thinking about it as a pricing issue. Some may be thinking about it as a bias issue. We've seen AG in Texas bring an AI-based a suit against an organization that was entirely B2B. And so, thinking about where the consumer in that was kind of even a broader notion of what consumer protection is when we're trying to enforce a consumer protection law in the B2B context. Interested in your perspective about where you see the world spinning in the next period of time, the next couple of years on these issues as you start trying to see the AG have different views of this topic and how you see those being areas that clients need to understand in connection with their development and use of AI.
Well, it's a great question. I think it's timely because of the recent election, and that is you're going to see states be more aggressive in their pursuit of what they believe to be violations of their consumer protection statutes because of a perception, right or wrong, that the federal government will be less active and sort of favoring deregulation at the federal level. So you're going to see states more active in every area as it relates to consumer protection. And artificial intelligence is certainly one of them. I think you're going to see more, I think you're going to see more interplay between consumer protection and antitrust, consumer protection and traditional discrimination cases. And I suspect that this will be a bipartisan. You just mentioned Texas. I think this will continue to be a bipartisan issue in the way that you've seen bipartisan groups of states investigate what they call, quote, big tech, end quote. Although many companies that use artificial intelligence, I'm not so sure I'd classify them as big tech, but many of the AG just kind of lump them all in to the big tech space and say this is the kind of thing that impacts broad numbers of consumers, therefore broad numbers of voters, and therefore you're going to see more AG involved, at least over the next 4 years.
Yeah, really good. Maybe I'd ask one question as we close, Jason. Maybe my last question is, drawing upon, your long career prior to going into private practice um, as a member of law enforcement inside of an AG office, um, and having kind of been on the other side of many of these investigations where, now clients are going to be interested in trying to figure out how they respond. Any practice points that you would want to share about how they can, think about potential AG inquiry in connection with their development or use of AI? And importantly, how is it that they would want to best set themselves up if they start getting asked questions about their uses of AI in the future?
So I'm going to give you two answers. We talked a little bit about the bias audit. That's the first thing I'd definitely consider doing that at least once a year. But also the second answer to your question is to have a proactive plan as opposed to reacting to attorneys general sending subpoenas or CIDs, having an understanding of where you do the most business, which states are your priority states. So I'm just making up a state, Texas or Florida or New York or California, whatever your priority states are, understanding the particular actions that the AG has taken in that space and what type of injunctive relief they've looked for in AI related cases, using that injunctive relief to inform what you should be doing internally. Because I've seen at times that when AGs require a company to take a particular step, that is the kind of thing that you may want to implement before an AG reaches out to you with a subpoena or a CID. So keeping in mind your priority states, monitoring the state AG activity there, knowing the players, knowing their priorities, having an understanding of, for example, Attorney General Letitia James and her Chief Deputy Jen Levy, understanding that they are laser focused on making sure that artificial intelligence does not disproportionately impact women. And so having an understanding of what the priorities are in your priority states and then reviewing the cases that have been filed there the settlements there or the trials. I think those are the steps I would take. And I always recommend that my clients take those types of steps.
Well, terrific. Jason, really appreciate the insights and all of the valuable expertise that you not only share with me on a daily basis, but also with our audience today. So thank you so much for joining the podcast.
Thanks, Scott. Thanks for having me.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.